So in mediation, you have a lot of control over how a business is valued, if it is valued at all. I will not insist on having a valuation. Sometimes parties come to us and say that they don't want to expend the resources and have the expense of having to have a business valuated, and that they have some idea of a fair resolution that they want to go with. And as long as they are knowingly entering into that agreement, understanding that they fully have the right to have a business valued, and even my recommending that they probably do have that business valued. If they are deciding that they want to waive that, then they can do that as long as they are knowingly doing it. But in other instances, they do want to have the business valued. And the nice thing about that is that we can choose when that will be done, and we can have some control over the expert that they hire to have that valuation done. It's not just automatically court ordered. And that is something that some clients feel very comfortable with. I always try to give my clients some option as to different business valuation companies or professionals that they can work with. The nice thing about mediation is that I don't just order that on them. They have the right to perhaps meet with those professionals, see what the costs and fees associated with it will be before they go ahead and go through with that valuation. And sometimes if one party has chosen a particular company or a professional to work with, the other party may want to choose their own. And that is an option as well. And that's what's so nice about mediation is you can engage in however many valuations you want. And sometimes people do want to have it valued more than once. And then we can talk about, perhaps comparing those results, taking an average of those two results to give us something that feels more fair to the couple. Many clients of mine who are business owners are very concerned about the exposure and the liability that they may have to go to court and litigate their divorce and to sit on the stand and talk about their business. And so many prefer to do it in a more private way, where they are just sitting down in my office and discussing it privately and having the ability to have things valued in a way that they are comfortable with. And so it definitely gives you the ability to resolve your divorce in a way that does not require the public nature of sitting on the stand and testifying under oath with respect to your business. A good example that I can give is that if you've got something going on in your business, some reason why you have to prioritize your business over perhaps your divorce for that day, there is no harm in a mediation in canceling and rescheduling an appointment. That cannot happen when you are court ordered to be at court for an appearance or hearing or deposition in your divorce litigation. So it really gives you as a business owner more control over when and how you will be dealing with your divorce in a way that will not interfere with your day-to-day business interactions. If you have a prenup or if you entered into a postnup after you got married, then that is definitely something that at the start of a mediation we will take a look at, because that can be very, very relevant to the distribution of the value of a business. Business assets that were acquired before the marriage are usually separate, but not in every instance. And it certainly can get tricky if there was the growth of a business that was perhaps started before the marriage, but then really took off during the marriage. Or it could be just the opposite. It could have really tanked during the marriage. And so that is something that we take a look at. But of course, if there is a prenup or a postnup, we have to be guided by the terms of that document.